wills. Thank you.
Thank you very much, sir. So still on that, Mr. Shedrack, who can write a will? And at what point? Yes, you said it's good for someone to put his house in order before he or she dies. But at what point are we expected to write our will?
Thank you. Anybody can write a will. The only thing there is that any adult, let me say, I think some states provide for 21 years, some provide for 18 years, but the idea basically is that an adult can write a will. One of the requirements for writing a valid will is that you should know what you are doing, basically. So the assumption is that a child may not know what they are doing, but an adult knows what he's doing. So any adult can write a will. And particularly, the law provides that you don't have to be a lawyer to write a will. Now, Aiko is looking at me because I'm taking food from her mouth. Let me clarify that. You do not have to be a lawyer to write a will. But my advice is that you should get a lawyer to guide you in writing a will. Because many things or different things can invalidate your will. There are technical, legal stuff that can affect your will. So it is advisable that you consult a lawyer to help you with writing your will, so that that lawyer will know the things to look out for, so that you don't end up writing a will that is not valid. So any adult can write a will and, be guided by someone who knows what the technical legal requirements are in that regard.
Thank you very much, sir. So now that we know that an adult can write a will, my next question is directed to Mr. Yakubu. What is the procedure of writing wills and codicils? Is there a specific procedure, or you just write it, since anybody can write a will?
Okay, good evening, church. Let me start from further expounding what a will is and a codicil is in relation to a will. A will is that you want to tell the whole world how your property should be shared. We live in Africa, and because of our extended family nature, I'm now speaking from the practical point of view. Because of our extended family nature, it is important that you define how what you left behind should be shared. Now, after writing a will once, the moment you discover anything else you want to add or you want to alter, maybe by reason of childbirth or by reason of further acquisition of properties, the law does not permit you to alter a will by canceling or doing anything. So you do a codicil. You can have as many codicils as possible to the main will. So let the grammar not be too much. Now, how do you write a will? First of all, having attained an age that is of a contract, you have the capacity to contract or get to write a deed, which is 21 as he said, or 18 as the case may be. I think for those who are in the force, they give them a lower because they can die at any time. So they give them that privilege. But for those who are not in the force, from 21, and then you have a few, like my lecturer would say, worldly possessions. It could be just a house. It could be just a share certificate. It could be just that money in the bank account. So once you identify your properties, the next thing is to identify your beneficiaries from your immediate family. We are in the church, so Christian marriage, whether you went to the registry or not, your family comes first. Your spouse is number one. And that is what is provided for in the administration of estate law in FCT, which is where we are. So whether you write a will or not, once you went to church to marry, you went into the church to get married to your spouse, she is number one. I lost a case against someone who went to court from a Christian marriage from Ekwa Church, Kafanchan. And then We said, no, the man's next of kin are his brothers. But the court said, no, the woman got married to him in the church. And it's a Christian marriage recognized by law. So she is first entitled to his possessions before his next of kin, so-called. So you identify your beneficiaries from your family, if you're married, if you're not married, your parents, your siblings, and then any other person you want to gift or will any property to. So after that, the next thing is to look at the value of these properties. And let me just use this song as a joke. So when what you give Mr. A, you also give Mr. B. Equality. Not necessarily in equal proportion, but let everybody get something. Let it go around. So identify the value of your properties. If you have a property in Asokoro, you know it's not of the same value with a property in Pape, Metama, or the property in Lube, or Gishiri, or Gwagwalada. So, having looked at the value of the property, you now decide, how do I go ahead to share these properties? And then you get, whether we like it or not, a lawyer to guide you. A surveyor and a lawyer, because the surveyor will help you with the market value of these properties or estate, and then the lawyer will help you in drafting the documents. Another thing, again, is to look at what else do you want to be done with these things, or to be done after you are dead. Because a will speaks from the grave. These are things that will happen after you are gone. So what do you want? Where do you want to be buried? How do you want to be buried? Where do you want your children to school? What else do you want to be done after you are gone? So after identifying all these things, the next thing to do is to draft the will. Tell the lawyer, these are the things I want to prepare the will. But in preparing the will, you also get witnesses, at least 2 witnesses who are of equal capacity to attest to the will, of equal capacity to also draft a will. These witnesses must not be beneficiaries. You get it? They must not benefit from the estate. So you cannot say, I'm drafting a will and my wife is a witness. That is not a valid witness. You get someone from outside, and thank God we're in church. I believe that we are all brethren. So you get a brother or a sister from church or from your workplace or from your circle of friends to witness the will. Then you get executors. These are people who will help administer the will, help in sharing the property. That is what we call administering the will. So when you identify all these, then you prepare the will, and then when you're satisfied, the next thing to do is to sign the will. This is very important, that the signing of the will can either validate or invalidate the will. These witnesses must sign the will at the same time. Write the date of signing the will and possibly the time. It is also important, now that we are in an age of information technology, you record the process of signing. Sometimes we go to the extent of video recording even the contents of the will, where the person who wrote the will is put on a video recording, and then he reads out the will in form of a video. He or she reads out the will in form of a video recording. So all of this, after signing and all of this, you now take it and register, and that is why you need a lawyer now, to take it to the probate registry in the High Court of the state where you are domiciled. In this case, you take it to Metama High Court, that one near NYSC headquarters or near CAC. That's where you should go to. Not Federal High Court, not Supreme Court, not Court of Appeal, but FCT High Court. The one in Metama, that is where the probate registry is. Since we are all in Abuja, there's a probate registry. In fact, it is downstairs. Very easy. So you access the probate registrar and tell him you want to register your will. Then you register your will. The reason why registering the will is very important, because this is a neutral registry. And then when it is time to enforce the will or to give validity to the will, you rely on the one in the court, so that the family members will not start quarreling over, he wrote this, he didn't write that. So for every will and every codicil, you take it to the probate registry for registration, so that at the time you want to give effect to the will, you rely on the one at the probate. And then the chief judge, as at the time the person dies, not you, but the person dies, the will is now called up by a letter. You just call out the will, and then you fix a date for reading of the will. Family members will be there, the beneficiaries will be there, and others will be there, and that's how you will now, the read will now be read out. And then a file will be opened for those who want to contest. But where you follow the provisions of the law, the procedure as laid down, and so many others that I don't want to bore us with, these are the major steps. Once you follow these steps, it is difficult to contest the will. And even when the person wants to contest, it becomes very difficult to prove a case. Well, there are cases in court up till now that have lasted 30, 40, 50 years over a will. But it is difficult to contest a will that has been registered with the probate registry, has been duly witnessed, and the executors are following the content of the will. And get trusted persons as executors, because especially for those of us who have so much here on earth, God has blessed us so much. So it is important you get trusted executors who will not connive with one part of the family against the other. I believe we don't have polygamous families here, but in case we do, it is more complicated for polygamous families. So it is important that these steps are properly taken. And again, the lawyer himself must be very neutral, not just one family lawyer who knows the one of the wives more than the other, or who someone brought to you by a member of the family, because there's Ojuku's will is being contested now because the will was written when Bianca was with him in London. And members of the family are here. They were not there when he wrote the will, and they are contesting that will with Bianca because most of the properties are willed to her. They are in court, and that's why I'm speaking about it. So it's important that we do these things in accordance with the procedure, and then we will be able to have a validly written will. And whether your property is just one land in your village, write the will. Else your uncles or your aunties or your cousins in the village will chase your family away. So it is important that you write your will. Even if you have 10 children and it's just one land, you can will that, okay, all of you are owners of this property and please don't sell it. And it will stand. Thank you.
Thank you very much, sir. I don't know, we have questions so far, so you don't forget your questions. Okay. There are two. There's one hand there.
Good evening. Thank you for the program so far. Now, my question is for the last thing you said. You said you can will it that they should not sell the property. Now, you've already given it to them, and then you're still giving an instruction. Can it still stand if they choose to sell it based on economic hardship? Thank you.
Okay, so it is expected that they respect the person even in death, their father even in death. And the reason why I mentioned that is because whatever the person intends is what should be contained in the will. And if you say you don't want them to sell the property, and it's there in the will, whoever is buying the property is buying problem. Because if you're buying a property, I'm sure one day you talk about property. If you're buying a property that is subject matter of inheritance, it is important that you see the will or the letter of administration, what gives the seller the power to sell the property. And if you have a lawyer who is diligent, he will go through the will. But your father said you shouldn't sell this property. And maybe it's just one of the siblings that is selling the property. So it is important that if you don't want them to sell the property, put it there in the will. Maybe you want to leave it as a family legacy because it's in the village. Or that's the only property you have. And you want your children and their own children to continue using that property. So you can write it there. And if they sell the property in disobedience, that is between it has its own implication. But the buyer himself should be aware.
Just add that, so if you have agreed to sell the land, and then if you are my brother, and our father has left us land, and we have agreed to sell it in spite of his instructions, and then you offend me tomorrow, I'm going to cancel that sale. Because I will go to court and say, this thing shouldn't have been sold in the first place. So, like he said, the person buying that property is really buying a problem rather than property.
Okay, praise the Lord. Mine is a concern about the peculiarity of our society. Even where there is a will, from the last speaker, where there is a will and it shouldn't be contested. But this is Africa, where family members feel cheated, or they feel, no, why should it be the immediate family benefiting all of this thing? And at the end of the day, they are using jazz. I don't want to mention some people from some specific region of this country, where you just mentioned one now, but I am not mentioning it, I'm not repeating it, so I'm not liable. The truth of the matter is, these things happen. From legal point of view, what do you think can be done to safeguard the living when the dead has gone?
Okay, maybe we'll take more questions and.
Praise the Lord. Mine is, where does the next of kin stand in this? Because you find out that most deaths that happen, you find out that one person will just decide to claim everything as the next of kin. Nobody gets anything. So I don't know, because as a government worker, there is a place that is provided for next of kin. So I don't know, where does next of kin now stand in will? Is it part of the will, or next of kin is on his own? I would just want us to.
Let's take the third one, then we'll answer. Okay.
Good evening, everyone. Okay, I am asking this question because I currently have an issue in the office. We have a client, or we had a client, and he passed on. So when he passed on, according to his will, his next of kin is supposed to be his wife. So meaning that his group life benefits are meant to be paid to the wife. But in the process of getting the EDV and trying to make the payments, his brother came up to the office and said that he is the next of kin, that it cannot be the wife that is the next of kin. So now we are in a fix as to who to believe and who not to believe. So what do you advise in this case? Because on our own part, we are actually trying to seek for legal practitioners to come into this matter, because his benefit is actually a very huge chunk of money. So what do you advise, please?
Okay.
Okay, in a situation where the disease has passed and he has property which he has already written will for, and before he passed on, he just acquired new properties and maybe he has amounts a lot of weight and he didn't include it in the codicils. So what will happen in that case?
Okay, so let me start with my brother here who made mention of family interference with will. Now, the effect of depositing a will at the probate is that it has a force of law. And when a will is given probate, the High Court, the Chief Judge of the High Court of that particular state gives the order. It's form of an order of a court, that this order it's hereby ordered that the will of Mr. XYZ, now deceased, be given effect and the beneficiaries take over XYZ property. Now it's like an order of court which can be enforced. If anybody who is not a beneficiary deals with that property, it's not just a criminal liability. You can send that person to jail and he will pay fine. It is there in our laws. Whether he has jazz or not, it won't work. Our law is no respecter of any jazz. Once you are the holder of a will and you are entitled to property and another person is coming, just take that person to the nearest police station. It's an order of court. Or enforce the provision of that will through the lawyer. That person will be sent for contempt. And he will find himself in Kuje or Suleja or Kefi, as the case may be. So it's a valid document. It's an order of court. And you know, when you say order of court, it's like a judgment. Because it's given under the hand, the probate is given under the hand of the chief judge of that particular state, recognizing that this is the wish of the dead man and that his property must be administered. In the High Court of FCT rules, I think it is 5,000 naira per day for violating, okay, that was the old rules. I think they've opted now. 5,000 naira per day for touching any property of a deceased without a will or without a letter of administration. Once you touch it, once you deal with it, it's 5,000 naira per day. That's civil liability. Then you talk of the criminal liability. So it's like that. And I think my colleagues will answer the remaining questions.
So you're asking what happens if you have acquired property. So the idea of you have acquired property after you have done the will and there's no codicil to assign that property. So to the extent of that property that is not in your will, that property is more or less intestate estate. That is, your will captures your property, that this is who I want to give what. So the part of your properties that you have not assigned to anyone is just like someone who died without a will. So the same process will go and get a letter of admin to assign it and all of that. So it does not feature in the will because you didn't mention it. The will is your expressed desire that this is what I want to do with my property. So your property that you did not express any instructions on cannot just be put in the will because it's part of your property. Yeah. Sorry? You go and your family can go and claim it. You have what you call letter of administration. You apply for I don't know if I've spoken about letter of administration. So you apply for a letter of administration to allow you take your relative's property. Sorry? People fight over will. How much more?
Sorry, sir. Just to add, what qualifies you to request that letter of administration?
We're going to talk
That's the
about
next one.
it.
Okay.
We wanted to take questions in relation to what has been said now. So before we go, she wants to answer, but I've seen that your answer and your next question, they are intertwined, so you just take everything at the same time. Okay, so the two speakers we're talking about next
the
of
other
kin.
person.
Yes.
Okay, so
yes.
Because she has not been answered.
Yes. You answer? Yes. So the two of them, their questions are related concerning next of kin. Can one person be a next of kin when applying for a letter of administration? First of all, what is even the letter of administration that we've been talking about? Because a lot of people don't know anything about it. So what is it? Can one person apply for a letter of administration, and how is it obtained? Then for the next of kin, how do they access what has been left? Like Mr. Friday asked, what is the place of the next of kin in for government workers and all that?
So letter of administration is, we mentioned will, and when a person dies having a will, you ordinarily don't have issues with the properties left. But where a person dies without a will, there is an issue. And the only way to sort these things out is to get a letter of administration. So letter of administration is that document gotten from the probate registry, like my senior explained to us, probate registry in high courts. That is, you apply, and people that can apply for a letter of administration, there is an order of priority. The spouse of the deceased person, the children, if they are not minors. The spouse, the children, you have the parents, it comes like that. The spouse, the children, the parents, the siblings of the deceased person, the maybe creditors, and a list of them like that. So where a person dies without a will, any of these people, but the priority, number one, is given to the spouse. So where the spouse is not available, the children, if they are not minors, the parents, and you should furnish reasons why you should be the one requesting for the letter of administration and not the people on the higher hierarchy as it lines up. So you apply to the probate registry requesting, listing out the properties or the assets of the person that you want, that you want a valid document to administer, a valid document to assess. You list them out, and there are requirements. You do a publication, affidavit, and a number of things that will be given to you there. And it's better, like they will mention, go through a lawyer, so you don't rigmarole, go, come back. So you get these documents, and you are given the authority to assess or administer these properties. So like he said, I realized that the next of kin thing is more of a procedure and more applicable when the person is alive, because whether you are the next of kin or not, when this person dies, if you have something in the bank or pension, you have maybe some insurance benefits, they will still request for this letter of administration or a will to allow you access what the deceased has. So it's more of a procedure that we must just pass through. But once the person dies, you will not be accorded the respect to assess this person's assets or anything he has. So letter of administration or a will is that which allows you to assess it. I don't know if I answered your question, but the fact is that the superior argument to it is the fact that you still need, once the person is no longer alive, you need to get any of these documents to allow you access this property, these properties. So that is it.
Okay, it appears, brother, on the question of next of kin is not satisfied. So literally speaking, next of kin means the next person to contact. It doesn't entitle you to any inheritance. It's just that our institutions have always mistaken it to be the person who is entitled to benefits. No, especially financial institutions, they've always fallen into that pit. The next of kin means the person to contact. And once you contact that person, he's ordinarily supposed to disclose these persons that she has mentioned: the wife, the children, and the rest. So if a man has his brother as his next of kin, it is incumbent on the brother, upon the death of that brother, to tell whoever, wherever he goes to, that this deceased has a wife. She's Mr. A or she's Mrs. A, and he has five children. And these are their numbers, these are their contacts. So they are the ones he's supposed to just link them to the family. However, because of how African tradition is, and because of how our institutions have misinterpreted the issue of next of kin, if you know that you are married and your next of kin is still your sibling, please go and change it because of the experience we've had. Just put your wife so that she'll be the next person to contact, or your eldest son, or any of your sons, so that that person will be the next person to contact. So, letter of administration, to add to what my colleague said, 2 people are supposed to apply. 2 people are given. And the legal implication of a letter of administration, as decided by the Supreme Court, is that they are just supposed to administer the estate, as it means. Letter of administration of the estate of Mr. XYZ. Not that they are beneficiaries of the estate of Mr. XYZ. They are just administrators. In fact, there's a decision that says they are akin to executors of a will. So the executors of a will are just to administer the will, same as administrators of the estate. So they are supposed to be trusted persons who will sit down and say, okay, we have recovered 1 million naira from his office. How do we share it amongst his family members? Even though in Africa you find it difficult. The moment the man collects the 1 million naira, he goes to the village and marries another wife. So it is important, because in order to protect your family, you put a member of your immediate family as next of kin. But ordinarily speaking, legally speaking, a next of kin is not the person who is entitled to benefit. They might be beneficiaries. That was why I made mention of Christian marriage. The administrators of estate law in FCT is that a person legally married to another, whether by registry or by Christian marriage, is the first beneficiary to the estate of that person who dies intestate. So that is the much I can say. Does it satisfy you, sir? To what extent? Okay.
Why I really want us to be clear on this. If you are coming from a background of the military, especially, and even the paramilitary, the police, I know it happened like that. You see that this nest of a king of 18 is really causing problem after the disease. It's causing a lot of problem because I have seen where next of kin is all, in fact, some next of kin claim everything and forget about maybe the wife or the children, or the elder son will claim everything and forget about this. So I don't know, is military part of this will of 18? Because it's happened in military, and it still happens now in the military. So I don't know if they are part of people that can write will, so that this thing will be cleared. There are many cases, even in Embelembe now, if you go, you hear this will thing, next of king thing. Is this next of king that you see that is happening there? Thank you.
Okay, let me speak out of experience because my mom was in the paramilitary before she passed. And obviously she had her next of kin, which is my elder brother. But upon her death, when we went to apply for the letter of administration, like he said, only two people must have that letter of administration. So we had to add my elder sister to so it depends on the family. It depends, once the person has his next of kin in his file, his office file, the family must agree on who the other person, because they will not release your benefits to one single next of kin. It will not happen. You have to bring a letter of administration that has two people as administrators. And it is advisable that the administrators will open an account that is an estate account. That is where all the benefits would go to. It's not to their own personal account. They open an estate account and the benefits will be paid there. And from there, the family will now decide on how to share whatever it is that comes. So yes, the military, they have next of kin. The paramilitary, they have next of kin, but they have to follow this process duly before the benefits are released to the administrators of their estates.
I just want to add on a general note to the other lady. Yes. So just generally speaking, don't use oral evidence to vary documentary evidence. Someone brought a will and said, this is the will that says what to do with this person's property. Then somebody else came and said, no, I'm his brother. Okay, I'm sorry for your loss. But is this I'm his brother I'm going to take to court? There's a document that evidences what to do with the property. So if you have a superior claim, then bring your own version of the will. Then we can now go to court to see whose will is forged and all whatnot. But you cannot verbally say that I'm his brother, therefore a will should be disregarded. So if I were you, I would advise that unless there is another will or a superior claim documented, don't use oral claim to vary a document.
Daddy, before you ask your question, I just want to add something on Dr. Babalola's question. Not speaking from law now, but one of the things I think can help us, especially with our kind of setup in Africa, where people, even though they know they will face the wrath of the law, they will do what they want to do. That is, if at all, the beneficiary will be alive to end up getting what he or she is entitled to. I think one of the things we can do is joint ownership of whatever it is we have, or even because it is hard for you to see the man. I'm not saying it's not happening, but it is hard for you to see the man having problems after the passing on of his wife. It is mostly the women. So buy these properties in her name. Empower them when they are alive. Let them have some things in their own names. Even the children, while they are grown up and they can handle things, let them have some things on their own. Let's not wait until we are dead and, family members now come and feel like, no, it's our brother's money. It's this. You did not bring anything to the house and all that. Let her have something in her name and on her own. And even the children then, when things happen, if at all they want to, you can leave that to them and face your own.
Okay. First of all, I'd like to find out, if you write a will and you did not register it at the probate office, what is the status of that will? That's number one. Number two, if in the course of getting a letter of administration, you now say, yes, it's just to administer, how will that property be shared? Is it going to be based on mere agreement, or it's going to be based on the culture of the people? That's one. The third one I want us to clarify is, assuming you have a letter of administration, and maybe one of your child is excluded, and is there any remedy for the administrators to cure that defect? If it's a defect, I'm using the word loosely. Thank you.
So let me start with the issue of non-registration of a will at the probate registry. The non-registration does not invalidate the will, provided that the will satisfies all the legal requirements of a will. The effect of registration before the death of the deceased is that it gives it a higher probative value. It's more higher security and probative value. It's easier to rely on. So where the will has not been registered and the person passes on before the registration of the will can still be taken to the probate registry to give it effect after his death. But then, if there is a contest, the validity of the will can be subjected to a form of contest if the family members are not together. But if they are together and are Christians in that sense of the word, and they believe the content of the will, they can administer the will and execute it without any rancor. So non-registration does not invalidate the will in any way, provided that the family members don't have any issue with it. It can be administered. And always the solicitor who drafted the will always have his copy. And then his own copy will be relied on. Thank you. The second question about the culture. Yes. To be administered.
What guys?
Okay, where there's no will.
Even when you say they are mere administrators.
Okay.
To dispense of
Yes.
the largesse. So how does?
Okay, what will guide the administrators of the estate in administering it? First of all, this is a very complex situation we have here, because once a man does not express how his property should be shared, the next thing to fall back on is culture. And the primary culture we should have that should guide us as Christians is the Word of God. And what does the Word of God say? Provide for everybody. Justice. However, if we are not going to rely on providing for everybody, then we will subject ourselves to the control of culture that says sometimes the first child takes everything. Sometimes you find that women are disinherited, even though the Supreme Court has ruled that culture is inconsistent and is invalid and is null and void. So everybody is supposed to be entitled to a form of inheritance or the other. So now by mutual agreement, you sit down, talk about it, and share the property. The elders in the family can guide, Other elders can come in. The church can participate. Elders in the church can participate. And a lot of things can be done. However, I made mention of administrators of estate law, which guides, which prioritizes who gets what when the other person is there or not. So you cannot have an immediate family and then the second generation family are now siblings of the deceased are trying to take over everything when the man has an immediate family. So it is important that the immediate family are provided for, and then if he has anybody he's owing, a bank loan or whatever he's owing, you pay up that, and several other things. But primarily, what guides you is your conscience, our faith, and then our custom. Our custom that is not null and void or inconsistent with good conscience, that disinherits a particular gender or a particular person, can be applied. Right now, we are dealing with a case, I think we are in court for about 6 years now, where a woman died and left an estate, a lot of houses and plots of land in Abuja. And then the son, ironically, is saying his sisters cannot inherit. Now here you are trying to inherit your mother, and then you're saying your sisters cannot inherit. We've been to IG's office, we've been to court, we are in the Federal High Court, we are in the FCT High Court, we are in several places over shares and the rest. And up till today, we've not been able to administer the estate because we are in court and because they refuse to agree. And this is 6 years down the line. Nobody has benefited anything apart from 1 or 2 properties he stole and sold. And those people were in court with them as well. So it's kind of messy when you don't agree and work together as the Bible provides. So that is why I'm sure we're having this conversation. Write something down. Administer. And even if you don't write it down, at least tell people what you want to do with your property. Or like she said, gift it while you are alive. Especially when you have female children and you are from that part of the country where women are usually disinherited. So as you acquire that property in Guzape, you give it to your little daughter and buy it in her name. The same thing with the child. The same thing with the mother. The same thing with your wife. So what will be left will just be maybe shares or money in the account or benefits from your office. And in which case, you will have taken care of the major things. But writing a will is very, very important. Because you can also write, now let me just answer that question. You can also write what you want to be done with your body, where you want your children to school, where the school fees should come from, which accounts should be used to pay the school fees, and several other things. You can give directions after death in your will. Thank you.
Okay, so
okay, if you have left out a child in writing your will, in the administrators, no, the administrators can do that. It is expected that they do that because that is a child, that your biological child, whether adopted or biological, you must provide for the child. One of the issues we have in court in that case I'm telling you about is that the deceased woman had 3 adopted children, and then the eldest son is saying no, they cannot inherit because they are adopted. So we said no, the law does not disinherit them. She has recognized them. She has given them the status of children in the family, and they bear her name. So right now, a proceeds of the estate from one of the going concern is used to pay their school fees. So whether adopted or not, the administrators should accommodate that child. In fact, the law is that you cannot disinherit your child. That is the law. You cannot disinherit your child. As much as you cannot deny any of your children, whether legitimate or not. So you cannot disinherit your child. If your child is disinherited, he should brief a lawyer. He can challenge that will. Because you cannot bring somebody to this world and not cater for that person. That's the jurisprudence behind that law. Thank you.
Okay, so further to that line of answers, how can beneficiaries of a will access Okay, so